Good morning, everybody, and thank you very much for joining us here today for this educational webinar. I wanted to first and foremost introduce myself. My name is Matt White, and I am kind of the face of this partnership here with HR Covered and the Niagara-on-the-Lake Chamber of Commerce. And I'm one of the senior account executives here. Work very closely with our clients as well. And I wanted to also introduce, this is our Vice President of Sales, Mark Nadeau, and our HR expert who will be the main host of the webinar today. This is Neil Cosby. So we're super excited to be working with Niagara-on-the-Lake Chamber and the opportunity for us to learn more about the biggest challenges when it comes to HR with businesses, and this is why we host these types of educational webinars to really grasp, some of these situations that are coming up and what's trending really in Canada as well. A big thanks I wanted to mention to Ryan and his team at the Niagara-on-the-Lake Chamber for organizing this with us, and we're super excited again to see what we can do to work together in the future as well. So what I'll do is I'll pass it along to Mark Nadeau, and he'll just go over a couple things, and then along to Neil.
Thank you so much, Matt. Great intro, and yes, big thank you to Ryan and the team as well at the Chamber. And those webinars are always meant to be educational, so it's meant to be time for you. So I'm going to be the host today, so I will not do most of the talking because you don't want to hear from me. I'm actually a former business owner who did my fair share of mistakes when it comes to HR management or unmanagement, as sometimes I like to call it. And thankfully, we have Neil here who will be able to go through all best practices with over 25 years of experience. Plus, on top of that, Neil is also your neighbor. He lives right next to Niagara-on-the-Lake as well. So fantastic to have someone local to help guide you around those intricacies. Now, if you look at the bottom or at the top of your screen, depending on your Zoom setup, you will be able to see Q&A. It's not something you usually see on the regular Zoom that you have with family, friends, or likely in business, but for a webinar setting, you do have the Q&A. So if you have any questions, please use the Q&A icon to type in your questions. I will be monitoring all of this, so if it is appropriate to ask the question right away to Neil as he goes through different topics, we'll do. If it's better to wait until the end to ask that question, we'll do that as well. But just be rest assured that we will go through all of your questions. Everything will be addressed. So thank you for attending the webinar today, and we'll pass it on to our senior HR consultant, Neil Cosby.
Thank you very much, Mark and Matt, for that wonderful introduction. And it is just a pleasure to be here today. When I was asked to present, and they said it was for the Niagara-on-the-Lake, hey, right in my backyard, as Mark said. So I'm very pleased to be able to present to you today. We do have a fair bit of material to go through, and I want to be cognizant of people's time because we have scheduled an hour. So at times, if I talk a little fast, it's just because I'm trying to get through the information, but feel free to ask for clarification on anything or questions on anything as we move forward. So we're here today to talk about impending legislation with Bill 27. The big piece that people are asking questions about, that I'm sure some of you are asking about, is the right to disconnect piece. So just to start off with, there are other pieces to this that we will talk about on a smaller margin, but the right to disconnect is what I think most people are kind of concerned about, and with good reason. So we're going to get through that. And actually, I'll just flip to my slide as to the overview. You don't need to see our mug shots. You know who we are. So we're going to be talking about a number of things, including the right to disconnect. After that, we go through the right to disconnect in Bill 27. We're going to be talking about some things that we are seeing as Matt talked about, trends and things that we get approached on when clients need our services. And it is definitely terminations, employment contracts. What can I classify my employee as? Can I take on independent contractors? There's a ton more that we could talk about, but we'd be here until next week. But these are the key things that we want to focus in on for you today. So, right to disconnect. So as of this Friday, all organizations that have 25 or more employees must have this requirement in place. And just to clarify, it is 25 employees in Ontario locations. If you have 25 employees, but they're spread out in Ontario, Alberta, BC, you need to look at your Ontario headcount in order to see if this applies to you. And every successive year by March 1st, the policy needs to be updated. This is totally employer driven. Although some of you, and certainly some questions we fielded are about what clients may see as this being restrictive, there is some flexibility with this. And you can customize the policy in being mindful that you may be a 24/7 operation. Not everybody works on a 9-to-5 schedule as well. You may have employees that work different shifts, and therefore when their right to disconnect may be different than other employees. Plus, we can't forget that emergencies do crop up. So does that mean you can't contact employees? And the short answer to that is no, and we will talk about that a little bit more. So when we looked at and reviewed the right to disconnect policies, from our perspective, this is kind of just a solidifying of what is already there under the Employment Standards Act. And again, if you're not familiar with the Employment Standards Act, that is the minimum thresholds that all employers must abide by. These are the minimum things that employers must provide to their employees. Things like hours of work, when does overtime kick in, how much vacation, when do I have to give breaks? So as I said, this is just a reinforcement of the parameters around when can we engage employees in work without impinging on any of the employment standard perimeters. Worker classification. So this is, and what this means is which employees are covered under this legislation. At this point in time, our perspective is this is very vague in terms of who does this cover. I would say that at this point, you want to operate under the assumption that anybody who is a non-manager is exempt, this policy applies to them. When it comes to exempt employees, because traditionally under the ESA, managers, they are not covered by OT provisions or any of those work things. They are allowed to work as much as they want. The employer can ask them to work as much as they want, within reason, of course. So how does this impact your ability to contact any employees if you have to have this right to disconnect policy? So again, it's taking a look at what is your business? What are your operations? There is no cookie cutter approach to this from our perspective. It's going to have to be customized to the organization, but keeping in mind there are some guidelines around this. Definitely with the last 2 years of people working remotely, there has been a little bit of a blurring of the lines of when are people working versus when are they not working. And of course, we're all committed. I know people on this call are all committed to a work-life balance, the wellness of their employees. So you don't really want them working around the clock. However, you want to be able to be confident that your operational requirements can be met. And just because you're a 9-to-5 operation does not mean things don't happen outside of those hours. So again, one of the things that, excuse me, we have been doing at HR Covered, the consulting team, is working with employers to find out how does this fit within their environment? What can we do and can we not do? Or I should say, what can the employer do or not do so that they're still compliant with the spirit of the legislation, but still able to meet operational needs. And again, a basic starting premise for me is always what is likely to happen outside of hours that you need to contact your employees for. Do you have an on-call system? I know given our client lists in IT and other types of services, actually, now that the weather is 30 degrees plus, air conditioners are breaking down. And I actually had a question from an air conditioning client the other day about, can my guys still go out if air conditioners break down past working hours? So, Mark, you've unmuted yourself, so I'm going to take that as a cue that there might be a question.
Well, it's, yes, there is. Thank you, Neil. So it's actually a question for me. And it's actually based on a lot of the calls that we receive from local business owners around the right to disconnect. And I think you're kind of going into the tangent as well in terms of, what is acceptable, what can I do? So for example, if it's a 9-to-5 business, and I know there's so many different factors to consider, but if it's a 9-to-5 business and let's say the manager always reaches out to his or her team members, let's say at around 8 p.m. to plan the next day and ask questions, is that something that they can still do? And if they can do it, should they expect an answer from their team members?
That's a very good question, Mark, and thank you for the prompt on that. Yes, this does not preclude you from sending out emails or leaving voicemail messages to your employees in preparation for the next day. The big piece there that Mark is talking about is your policies can read that, you can do that, but there is no expectation of a reply from an employee that is covered by this legislation. So if they get a call if their hours are 9 to 5, a supervisor contacts them at 9 o'clock at night, there is no expectation that the employee will have to reply until their shift starts again at 9 o'clock the next day. So I hope that clarifies.
Yeah, absolutely. Thank you.
You're welcome. And thank you again for the prompt, Mark. Again, because employers have, with technology, we've enjoyed a greater amount of flexibility with the ability to contact employees to get work done. I think we have to be, what this reminds us is that not everybody is wanting to work after hours. I mean, as I look at my three colleagues, I know I'm receiving emails from them, at all hours of the night because that's just our choice. But that's not everybody's choice. So you have to be mindful of, that there is a reason for this legislation. It is to create that work-life balance and have wellness and make people more more rested for when they can come back to work. However, you still have your operational needs. It's all about the balance. So with that, I'm going to move on to kind of some of the other elements that you might want to think about. And as I looked through and re-looked through some of the research some of the legislation, one of the key things that sticks out to me after this is the ability of including a non-compete in an employment contract. And if you're not familiar with non-competes, that is something that employers were able to put into a contract so that if an employee left, they had the flexibility to say they could not, and there was a lot of variance in the language. It was around setting up a similar business for a period of time. It was about joining a competitor for a period of time. And that provision has now been struck down by the provincial government. That does not mean that it precludes your ex-employees from using your confidential information, your proprietary information, soliciting former clients or former employees. Those things are still very much in force, but this is all about their ability to be working or setting up a competing business. And right now they are, with this new legislation, they will be allowed to do that. So I know at HR Covered, we've taken those non-competes out of our employment contracts. And again, be mindful. I just want to be mindful. This is for Ontario only. Non-competes are still in force in other provinces, as far as I'm aware. So, Mark?
So in a case like this, Neil, that means that the importance of having a non-solicitation and confidentiality clause is even more important for employers today in Ontario because of the fact that non-competes are no longer enforceable.
Absolutely, Mark. I know we've taken strides to beef up the language, if you will, around the non-competes, around the non-solicits, around the confidentiality pieces, so that, yeah, okay, you want to go start your competing business, your competing HR consulting business, that's fine, but you're not using any of our stuff, and that will be held up anytime that is challenged in a court of law. So, yes.
And also, I think with the non-solicit piece, we can also make sure that we protect our clients and our employees, because especially today where employees are so hard to find, you don't want someone to leave and then come back in and say, hey, come with me. It's way better over there. You know, we're going to have a lot of fun.
Absolutely. Absolutely. Yeah. It covers off. So these things cover off so much, which protects the employer, as you've said, and maintains your competitiveness in your business or your sector as well. So we're moving into the realm of employment contracts and terminations. But I wanted to talk a little bit today about, how do you mitigate your in mitigating your circumstances with getting in a situation where you're looking at a termination. One of the key things that I find is the hiring practices of the organization. And right now, as Mark mentioned, because of the labor market shortage, the war for talent, whatever term you want to use, we're finding a lot of our clients are going outside of their normal process with respect to hiring practices that, quite frankly, might be putting them at risk. I can understand why. It's, if you've got a client, if you've got an employee in front of you right now, seems like a good fit, but if you have to do in reference checks, which is a normal and should be a part of the process, in between you completing those reference checks and then getting back to that candidate, they could have been scouted by another employer or scooped up by another employer. So again, it is our recommendation not to cut those types of corners, to follow your process in terms of interviews, multiple interviews, reference checks, background checks, to ensure that you can have a good hire. However, we're not naive. We know how tough it is out there. So it's just to be mindful. But even beyond that, your hiring practices should be structured. There should be things in place like job descriptions, which, again, for those that are not aware, that is a description of what the person is going to be doing, the duties, the responsibilities, the backgrounds that are required. And it also indicates a key piece here. What are their key performance indicators? How are you going to be judging them on their performance? That is key for when you get to performance evaluations and assessing people. Are they cutting it or are they not cutting it? Mark?
Thank you, Neil. And job descriptions. I mean, we talked to a lot of local business owners and leaders and executive directors, and basically a lot of the time they say, well, they know their job description was part of the job offer that, they actually applied for, or the job posting that we had, they understood what they were applying for. So is that still valid if it's just in the job offer, or the and not in the contract and not in writing and confirm when they actually start with the organization?
Yeah, the best practice and the best thing that any employer can do is make sure that the individual they're looking at has a copy of that job description, either as part of their job offer or as a separate document, and they're signing off on it so it is understood between both parties. These are the expectations. And then there is no difference of opinion down the road. If something comes up and the employee, for instance, says, this isn't part of what I signed up for, here's the job description, you signed off on it, we reviewed it with you. So there is a common understanding there. Absolutely, Mark. Good question. So the other piece that counts in this process is structured interview questions. Free-flowing and informal interviews, they can be useful for future rounds if you have a multifaceted recruitment process. But as an initial interview, you want to find out what is, obviously you've made the decision to interview them based on their resume, their application form. It looks like they have the technical skills required. So you want to dig down and find out not only about the technical skills, but are they a fit with your organization? Do they have things like similar values, similar ethics? Is their personality going to be a fit with the team that you have now? So those are things that with a good structured job interview questions, you can really get nailed down and find out if this person's going to be the person that you want for your organization. It also gives you something to ground your decision in. I hear this a lot, and I'm going to admit I'm guilty of it too. My gut tells me the person's going to be a fit, or my gut tells me I'm not so sure about this individual. It is a best practice to, okay, what is the real reason we're hiring this person or not hiring this person? And I can tell you from my experience, and especially in this day and age, when you advise unsuccessful candidates, they are most likely going to ask you, why didn't I get hired? And it is always good to have your notes ready to say, we asked you this question, this was the answer you gave, and we don't feel that based on your answer that this would be something you have in order to meet our requirements. Mark.
And I mean, and that portion is so critical for business owners and leaders whenever they do interviews, because if you don't have that process and the same process for other people that you talk to, then what can happen is someone can take questions out of context or make up something else that might have happened. And a quick story about one of our clients who's an insurance broker. What happened to them is they were hiring someone for an admin assistant, and they posted a job and they got a few resumes, and they've interviewed a nice lady. She was 62 years old. She comes in for the interview and she doesn't get the job. And then she felt that, and they had no framework for their interview process, so nothing that was the same for everybody. And then she filed a complaint with the human rights, and she said, they decided not to hire me because of my age. I'm sure of that. And they had no process. There was nothing in place. And then the human rights asked questions around what process do you have in place? Can you show us what you do during your interview process and the questions you ask? And is it the same for every candidate? And they didn't have that in place. But what saved them was that the person that they actually hired was 64 years old. So at least they hired someone that was a bit older than the lady making the complaint, but they dodged a bullet. But that piece there is so important for employers that are listening to us today.
Yeah, very good point, Mark. And again, I'm of the opinion that, most of employers are acting in good faith when they make these hires. And, what you were talking about to me is what I always say is perception is 9/10 of everything. So just to a very quick story to dovetail on Mark's story is I was in an interview process, and this has actually happened a couple of times, and managers are trying to make small talk to get the candidate comfortable so that they can put their best foot forward, and they nonchalantly and innocently ask, "So how many children do you have?" And my eyes get as wide as saucers, because that is absolutely not a question we are allowed to ask in an interview process. That has no bearing on whether we make the decision to hire or not. Is how many children do you have? There's a little bit of a stigma with parents with young kids, especially for females, and especially if they're a single mother. The perception may be that they will be the ones taking care of the kids all the time when they're sick. Fortunately, in both of these situations, it didn't amount to much. In one situation, I made light of it. I said, "Oh, you've forgotten your interview training," and that's not a question we can ask. That was a very good practice for everybody else. You don't have to answer that question. Fortunately, again, nothing came of it. I can't remember. I don't believe we hired either of these individuals for the outcome, but it wasn't because of that. But again, seemingly innocent things can, if people perceive them in a slighted way, you could be asking some questions which easily defendable, but very impinging on your time as well. So again, you're going to get a copy of these slides. So the risks of not doing the due process, the due diligence with the recruitment process can lead to things like this, where you're having to pay out for a bad hire a significant amount of money based on severance, training costs, production costs. You yourself may get a reputation as an employer that doesn't do their due diligence, gets bad hires, and turnover is high. So again, just moving on for the sake of time. One of the things we want to talk about is, and we see this all the time with our clients, classification of independent contractor or employee. And by independent contractor, just so we're clear on what we mean, that means somebody who is not on your payroll. They are not an employee. It is almost like a vendor relationship that you have with somebody where they are delivering services, usually related to your business, but they work for themselves. They're responsible for their own deductions. They invoice you for the work that they do. And there are other things which delineate an independent contractor from an employee. There is the test about, are they using their own tools? Do they have an email address with your company? Are they subject to performance expectations? Are they exclusive to you, or can they go and provide and get other business? Again, I know from my experience, we have a number of clients that use this model, and some of them still continue to use it, even though we have provided them, done our due diligence and provided them with the risks that if they continue to use it, if somebody takes a closer look at their independent contractors, they might not meet the threshold of being an independent contractor. And I know for a number of smaller organizations, a number of startup organizations, and even some medium and larger organizations, the use of an independent contractor, it's cost efficient. There is no doubt about it. You're not responsible for CPP, their portion of CPP, EI, other mandatory deductions. You don't have to pay for their WSIB. But be cautious with the use of the independent contractor, because one of the other key things that they look at is this an integral part? Is this person in a role that is an integral part of your business? So if you've got an IT company and all your IT professionals are on an independent contractor, that might be considered integral. Whereas if you bring in an outside person to be your HR consultant, yeah, that's a necessary administrative function, but it is not a core part of your business. The HR consultant is not out there providing IT service to your company. With respect to employees, of course, when you bring on one employee, the fundamental nature of your business changes. There becomes, and again, this isn't to scare you away from having employees. It's just there are obligations, and we can definitely help you navigate this. But there are things like, as I've mentioned, the mandatory deductions for CPP, EI, and the like.
And when it comes to independent contractors, sometimes people have a perception of, well, they have their own business and I had them sign a contractor agreement, so they're a contractor. Is it that easy, or really the test actually will will just make or break that relationship?
Even regardless of if they sign an agreement, if the contract is not enforceable because they are they do not meet the threshold of an independent contractor, that contract is not worth the paper it's written on, to be quite honest. And typically, again, we've had clients that have been using this model for years, and some of them have said, I appreciate the advice, but I haven't been caught now, so to speak, so I'm going to continue to use it. And hey, we've done our due diligence, and we're here if you want to revisit that process. However, how does this come to the attention of people like the CRA or the Employment Standards people, the Ministry of Labor? Well, there's a couple of ways. It could be that you have an independent contractor who has a different understanding, and they believe they're an employee because maybe they've been exclusive and things of that nature. So if you make the decision to let that independent contractor go, they may decide to look into what are they entitled to because they believed they were an employee. The other thing is CRA may take notice of when you file your business taxes, and that is when we get the calls about, I didn't know. And again, lots of innocence around this. Absolutely, people felt that they could do the independent contractor model. You only know what you know. So there's no judgment there, but it is a risk. I also want to delineate between the use of the term independent contractor and contract employee, because I often get prospects and clients saying they're contractor, they're on contract, and that's different. A contract employee is someone in our world that is on your payroll. They are an employee. The difference is they are working for you for a specified amount of time, and at the end of that specified amount of time, you don't owe them any severance or pay in lieu of notice because it's been agreed to that they're only working for you for that period of time. You may see these things in like maternity leaves or some project-based work where they need some help for that period of the project. Mark?
And I don't know if anyone on the call actually remembers that one, but there was a case a few years back with a funeral home where the funeral home was acquired by a larger corporation, and they gave the former owner of that funeral home a 10-year contract. So it was a term contract, but the contract was not very good. It wasn't complete. There was a lot of stuff missing, and more importantly, there was no termination clause or no specificity around how this contract would actually end. And because of that, I believe after 2 or 3 years of service into that 10-year contract, they decided to terminate that relationship and basically let the guy go. But then because it was poorly drafted, then they were actually on the hook for the 7 years that were left to the contract. Wow. So how important is it to actually have a proper termination clause, even in a term contract?
It's very important, and typically it goes something like on either side can give 2 weeks notice to terminate it. But you brought up another good point, Mark. How long can you have people on contract before they look like a full-time employee? The general guideline is no more than 2 successive contracts, because then it becomes more like a full-time permanent relationship. This kind of guideline came about as another case where the individual was actually 19 years on contract. And then they made the decision they weren't going to renew, and they felt that they did not need to give her anything because it was a contract role. It went to court, and of course they said 19 years is a full-time permanent relationship, and she was given the monies that she was owed. So again, we work with a number of not-for-profits, and in not-for-profits, it's tricky because some of these roles, these jobs, are dependent on funding, and if the funding gets renewed. So a number of our not-for-profits do have people that are on long-term contracts year to year that they sign every year, sorry. However, they are aware of their obligation that just because this person has been with us on contract for 5 years, we renew their contract every year. Once funding is secured, we know that if we let them go or we lose funding, we're going to owe them in the past. So again, in some cases, it's okay to still have those year-to-year contracts. Just be mindful it doesn't excuse you past about 2 years of your obligations to provide pay in lieu of notice or severance if it applies in some cases. So what are the costs of misclassification? So there's a couple of things here also with misclassification that I wanted to talk about. We'll finish off with, if you misclassify somebody as an independent contractor versus an employee, well, they'll look back and they'll see how much did this person, and it also can be detrimental to the person who's an independent contractor as well. They may be on the hook for paying some of these mandatory deductions as well. But the employer, they may look back to see how far back they've had these independent contractors, and will do the calculations of how much CPP, how much EI, things of that nature is owed by the employer. The misclassified employee, of course, if they're found to be an employee, they could be owed things under employment standards and common law notice as well, which we'll talk about a little bit more. The other piece with misclassification is we have categories of exempt employees and non-exempt employees, which we discussed a little bit earlier. The delineation there is, are they managers or are they not managers? And there's a clear definition of a supervisory staff member. Do they guide, direct, plan, are responsible for getting work done by others, and do they have hiring and firing powers? That delineates a manager or a supervisory person. Typically, non-exempt employees do not have those powers, so to speak, that authority. However, we know that some employers will use terms like lead hand, foreman, or they will give people a manager title, but they're not really managers because they're hoping that this will satisfy that they can have the person work OT when they need them to be. Again, there's a couple of cases here where those have been challenged and the results have not been positive for the employers where misclassification has been found. Employment agreements. This is the most important document. So you've done all your due diligence with your recruiting. You've made the decision. This has to be an employee. And also, just to finish off with the independent contractor piece, we at HR Covered also provide independent contractor arrangements if that is still a route that you would like to go. So we can mitigate your risk there because, like I said, the independent contractor is like a vendor relationship. Mark?
And a lot of people, when it comes to the contract of employment, will have a letter of offer and or just a verbal contract, because a lot of people believe that the contract is only for larger corporations. I don't need to have one because I want to hire them forever. They're not on salary, they're hourly. I don't need a contract for that. So there's a lot of misconception around who the contract should be for. So who exactly, what kind of employee should have a contract of employment?
Everybody. I have a couple of teenage kids that are, getting into their first jobs now. They're working in restaurants, and they come home with absolutely no paperwork that delineates or puts out what are their hours of work, what are they classified as. Within an employment contract, there is the notion of consideration. What is the employer giving to the employee in exchange for their services? And that covers so much. It's not just about a wage. When you do not have an employment contract, it leaves you, the employer, very vulnerable. The employee is actually not as vulnerable without an employment contract. I'll give you a very quick story that I just dealt with. So one of my clients, 15-year employee, no contract from day one. And over the years, while the individual showed good performance in the first little while, it degenerated after about 2 or 3 years. However, tight labor market, the costs of retraining that person, they never engaged in correcting performance or in a manner that would have possibly headed this off. They got to a point where they made the decision to terminate, and it was a huge risk. 15 years, a person in their mid-50s, it could have been rather expensive for the individual, but for the client, but fortunately, the employee signed off on something that was much less than had she pursued it a bit more, she would have definitely been entitled to a lot more money. At 15 years, with her age, with the possibilities of getting another job, they were looking at anywhere from 13 to 18 months common law severance, which we'll talk about in a little bit more. I'm kind of jumping the gun, but I wanted to reinforce Mark's notion that an employment contract is solid backup for this is the agreement we have from start to finish. Mark?
It's interesting because I know you brought the word severance, and a lot of people who are, under, I think, 2.5 million in payroll on a yearly basis believe that severance does not apply to them. But then severance is a term that is widely used to also talk about termination pay. Is that correct?
Absolutely. And, we're jumping a little bit ahead of the gun, but it's all part and parcel of what we need to impart here. So when it comes to, you get to the point that you've made the decision, I'm letting the employee go. And in most cases, this is dismissal without cause. And we'll talk about dismissal with cause in a little bit, but just very briefly, it's a high threshold to prove. In a dismissal without cause, and that could be a layoff as well, shortage of work, business winding up, that's considered a dismissal without cause. There are three separate pieces. Under the Employment Standards Act, the employee gets a week for every year of service or partial year of service, starting at 3 months, up to a maximum of 8 years. Then there is the severance provisions under the Employment Standards Act. As Mark mentioned, if you have a global payroll of 2.5 million and the employee has worked for you for 5 years or more, that individual is entitled to severance provisions up to a maximum of 26 weeks. And again, it is based on their tenure with you. Then we get into the notion of common law provisions. And this is where Mark mentioned that some employers may feel that this is not relevant to them as a small employer or a medium-sized employer. It absolutely is. All of these provisions are relevant to employers, no matter what your size. And these are the things we talk about. There is no cookie cutter approach to this. Each case is decided on its unique facts. But there are some parameters, as I mentioned in my example, around years of service, the age of the individual. If the person is in advanced ages, there is a feeling that their ability to secure another job is going to be limited. The ability to, and when I say get a job, I mean a similar comparable job with the same compensation, the same level of authority. There's also variables of their past performance. What about, can they get a job in the geographic area that they're living in, or will they have to move? And then, of course, there are a number of other things that come into play as that they will look at. If this gets to in a court of law, and again, it's like a funnel, the number of cases that end up before a judge or an arbitrator is less than 2%. But if it happens in those extreme cases, those sitting in judgment will rule on the balance of probabilities and what is a reasonable period to provide to this person given their life circumstances. Sorry, I just lost my train of thought. So typically, these things are negotiated between a lawyer or your friendly HR consultant when these things are challenged by terminated employees. So getting back to the employment contract, it has to be rock solid. It cannot use ambiguous language. Some of the more key terms, of course, are around what is your classification of employment? Are you full-time, part-time, casual with no guaranteed hours? What is your salary? Are you salaried or are you paid hourly? What is your role? Are you an exempt individual or a managerial person that you are exempt from some of the provisions of the Employment Standards Act? What are you agreeing to for vacation? What are you agreeing to for benefits? Probationary period. Every individual should have a probationary period. I know the standard, most likely, if you are using probationary periods, you may use 3 months. That is, from my perspective, too short of a period of time. It should be 6 months, 9 months. At 3 months, an individual is just getting their feet wet. The reason employers like to use 3 months is that if you have a probationary period past 3 months and it goes past that, if you let them go in that 6 months, say a 6 month probationary window, you then owe them a week's pay in lieu of notice. So that is one of the reasons the 3 month is most popular. Food for thought. And there is nothing in legislation that even says you have to have a probationary period or the length of it. I myself, before I was into consulting, I worked with organizations that I was under a year-long probation at some places. And I know that at some organizations, there's a 2-year probationary period. So you want to have an appropriate probationary period that meets your needs. So as well as some of the, I'm just cognizant of time, some of the key features, we've talked about non-solicits, protection of proprietary information. That should absolutely be in there. We've also talked, one of the other key things that we need to pay attention to are termination clauses. So there's 2 things with this. Our employment contracts talk about termination without cause, and we specify concretely the actions that will justify a termination without cause dismissal. So that is absolutely necessary to identify to employees. These are the things that will get you, A, get you into trouble, and B, get you terminated from our organization. And the only thing we have to pay you is your outstanding wages and any accrued vacation. In a dismissal without cause, like I've mentioned, and as Mark started that conversation, there are the ESA provisions, which are non-negotiable. We have to abide by them. Now, the common law provisions, you can put clauses in there that limit the person's abilities to collect on common law provisions. And then that mitigates your circumstances so that, you know, whatever figure you decide on or whatever period of time you decide on, no matter no matter at what point they're dismissed without cause, that's what they get. So if they're dismissed without cause after a year, they get this amount. If they are dismissed without cause after 3 years, they get this amount. Again, I just can't put in the importance of that clause. The other thing I want to mention, I think it's in a further slide, but employment contracts need to be signed before the person starts. Do not have them, I can't reinforce this enough, do not have them sign it the day that they start. They come in, you've had verbal discussions, you present them with the contract and, well, hey, this isn't the wage that we talked about. This isn't the amount of vacation we talked about. Then you've got a problem, potentially a problem. So again, as well as the job description prior to starting, the employment contract should be reviewed, signed, and you have to, in your employment contracts, you should put in there that you should suggest that they have it reviewed by a lawyer. Not many people will do it. It's not the same as with terminations, where people are more likely to go to a lawyer, but it is something that is available to a prospective candidate if they want to have it reviewed to make sure that everything they're being offered is clear. There's a couple of cases cited here, and I've talked about one of them. You have to use solid language so that there is a clear understanding of this is what we're giving you in exchange for your services. It can't be unambiguous, vague, anything like that. It will likely not hold up. The chances of a defense are minimized when it is ambiguous language. The second thing with the Waxdale case is this is like the fruit of the tainted tree. So in that case, the termination clause was actually quite solid. It was another piece of the contract which went against. It actually did not meet ESA standards, and therefore, when the person was terminated, they challenged their termination clause because this other piece just, you know, contaminated the rest of the contract, and the courts agreed with them. Mark?
And that's such an important judgment, right? Because essentially, I believe pretty much whoever we're talking to now who had a contract of employment drafted before June of 2020, most of the contracts are no longer enforceable. So if someone on the webinar watching this today is part of this, where your contract of employment was drafted prior to June of 2020, make sure to get it reviewed. I know we can do it for you guys as well at no cost to review your contract of employment, make sure they're enforceable, because that's such an important portion. Because otherwise what happens is you have that safety net, because you're like, hey, yeah, we have good contracts, they were drafted by a lawyer in 2016 or in 2019. But ultimately that safety net is now full of holes and will not hold anything coming its way. So make sure that this is drafted properly. We're happy to be supporting you with that as well, thanks to the partnership that we have with the Chamber and how much they care about you. And something else that you've mentioned before, Neil, is you touched on the fact that, you know, the employee has to sign the contract before they start working. And that is extremely crucial. Otherwise, the contract is no longer enforceable. But what happens if, as an employer, I have employees right now in my organization and I want to give them a contract? How does that work? Am I allowed to do that?
So if they've never had a contract before, Mark, is that what you're alluding to?
Yeah, correct.
It's definitely within the purview of the employer to say, and I've just done this recently with a couple of people, and I mean that's one of the reasons people come to us as well, right? So they can they can request employees sign a contract. typically there is the explanation, we've never had this in place. This is not only to protect us as the employer, but this is also to protect you as the employee. I mean, all we have is verbal agreements. So if you are engaging in a first contract with an employee, one of the key things that you have to, there's two key things. Explain it to them. Don't just present it to them out of the blue. But also there has to be some, I've used that term consideration before. So when you are presenting them with a contract, it is best practice and binds your contract to give them a one-time bonus, something for signing their in contract. The employee has to get something out of signing a document that they've never had before. The second thing is you can give a time frame for the employee to sign by. Absolutely, they can go have it reviewed by a lawyer, make sure that they're comfortable with it. But if the employee does not sign after that time frame, and the time frames vary, you may be in a position where you can say to that employee, "You haven't signed it. We're letting you go." And also, just to add to that part, just because you've given an employee a contract when they start, it is a good idea to refresh those contracts typically every 3, maybe no more than 5 years. Things change, the job changes, legislation changes, and if it's not included in there, it doesn't count when you get into things like if you have to let them go. And again, that's something that we've assisted a number of our clients with before. I'm just mindful of time, so I'm probably going to zip through this a little quicker than what I normally would. We've talked about just cause. This is serious stuff. Some of the slam dunks that I have experienced, and that is in case law, is in the case of violence in the workplace, fraud, theft. Those are things that are concrete just cause dismissals or dismissal with cause. As I've said, in these situations, you can give, all you owe the individual is their accrued vacation and any outstanding pay. And that's it. You don't have to give them severance or anything. However, it is a tough threshold to uphold outside of those examples I've just given. So if you are going down the path of, no, we want this to be just cause, your documentation has to be absolutely rock solid. It has to outline exactly why you think this is just cause, because your HR rep or your lawyer rep will be drafting that termination letter and has to have those specific details so that we can back up and support our claim that this is a just cause dismissal. In most cases, we're probably recommending to individuals to go the without cause route because we don't, outside of those examples I've just given, because we don't feel that the just cause will be defensible. Very quickly, constructive dismissal. If you change a employee's contract to the point that it is so significant, it may not look like what they originally signed up for as a job, that is considered constructive dismissal. So some of the elements are taking away some of their authority, reducing their pay, things of that nature. And what this means with constructive dismissal is that you may have to pay them any kind of severance or pay in lieu notifications because their original employment contract is no longer valid. They're in a different role. They're in a different employment relationship with you. Now, there is a caveat to that. And again, this is just recently, and this is fresh in my mind. One of my clients, a role was made redundant. They offered the employee a lesser position if they wanted to stay, which in itself is, constructive dismissal. The employee agreed, and therefore it was not, because they're not doing it, they're not planting it on them or implementing it without their input or say so, it's an agreed to thing. It does not count as constructive dismissal. So we've talked about ESA considerations in terminations, the notice period, which is a maximum of 8 weeks, and the pay in lieu of and you can have working notice as well, by the way. Instead of paying them out their 8 weeks, if you wanted them to continue working, you can say this is working notice, but that comes with its own pitfalls that I would be happy to talk to you about if you want to follow up after this call. Severance pay, we've discussed 5 or more years, 2.5 million, or the employer is letting 50 or more employees go within a 6-month period. And again, common law damages. This is probably your most vulnerable spot that you can mitigate with solid employment contracts, because you are at the whim of somebody sitting in judgment, taking a look at the facts that are presented to them based on those things that I mentioned about a person's age, any past performance issues, things of that nature. So I cannot reinforce, and I know I sound like a broken record, the provisions in your employment contract can really assist you with mitigating your circumstances in this event. So very quickly, when you have made that decision to let somebody go, it must be done with respect and dignity. I can understand that maybe you're getting rid of somebody who is just not your most favorite person. I get that. However, it must be done in a very a non-demeaning way, supportive way. You must ensure that the individual gets home safely. Offer them a ride. Ask if there's somebody you would like them to call so that they can get a ride home. You do not want the reputation of an organization that lets people go in a demeaning and demoralizing way. And there's actually damages you could face if that is the case, where it is done in a demeaning, belittling way. Okay, I'm 3 minutes over. I apologize for the rushed nature. I get passionate about these things. My apologies.
And I apologize as well for making it longer by asking you questions, Neil. And we do have a great question here from Sarah in the Q&A. So she's basically asking, can you provide an insight or any insight into dealing with long-term employees that are well beyond retirement age and being a drain on the company? So, for example, not able to meet their work requirements or their duties. Can an employer offer them a few financial compensation package options to help encourage the employee, let's say, to help encourage the employee to leave the business without termination?
Very good question, and one that we have faced numerous times for sure. The short answer to your question, Sarah, is anytime you are looking to transition an employee out, it is a termination. Unless they make the decision that they are resigning or retiring, you are left with, if they are not meeting the their core duties, not able to meet the performance expectations of the organization, then you must document that and provide. There's a few things you have to go through. If the person is not able to, does not provide any outstanding reasons why they can't meet performance, like physical things, disabilities, it has to be all judged on performance. If you are looking to exit, it is a dismissal without cause. It is a very slippery slope. I'm not going to, mince my words here. Even though you may structure what you feel is a very fair and reasonable package to exit the person, they could potentially file a human rights complaint. And again, I go back to perception is 9/10 of everything. So I hope that answers your question. Again, we're available for a further consult if you want to explore that a little bit further.
And then would there be different ways, because I think I added a word there for Sarah as well, and basically would there be, let's say, another way to help out the employee if she does not want to look at, let's say, dismissal or termination, but maybe help them through this without making it a constructive dismissal in any way?
If I'm understanding what you're asking, Mark, you know, there could be a performance improvement plan put in place to assist that's another thing with terminations where employers feel performance has degenerated, is that the courts want to see what did you do to turn the employee's subpar performance around. Did you support them? Did you have regular meetings with them? Did you notify them of what needed to be improved and how it needed to be improved? So it's an integral part. Sometimes, and I'll be very honest and blunt here, within a performance improvement plan, they're generally not successful. And that happens for two reasons. The individual realizes, you know what, I just can't do this job anymore. That's just the hard reality, and they resign of their own accord. Or the other piece is that we have to go down the termination route because the person has not shown any significant improvement in their duties and responsibilities. I hope that answers what you were looking for, Mark.
Absolutely does. Thank you so much, Neil. If we have any other questions. Sorry, Neil.
That's okay. And I do apologize for going over. It's a lot of information. And I'm going to turn it back over to Mr. White now to head us into the home stretch.
Yeah, thanks again, Neil and Mark. That was very, I think, very interesting with the stories and how I think we can all, relate to some of these different items in the world of HR and the complexity that every employer faces, I think, on a regular basis. So what I just wanted to do is really thank everybody for attending the webinar here today, and this is something we would love to do continuously, with the Niagara-on-the-Lake Chamber, and we also want to make sure that the attendants receive a complimentary consultation and a compliance assessment for joining us here today. So what we will do is we'll reach out and just schedule something promptly if you are interested in learning more about the services, how we can help from an HR perspective, because as we know, I think this is just a couple components that we've talked about today, and why it's so important that employers need to be well equipped around these HR items. So we can definitely educate you on more about what we do to work with our clients on a regular basis and learn more about your business and maybe some of the time constraints and the struggles that you come across on a daily basis. Again, I want to thank everybody, Ryan and his team, for organizing this with us, and we look forward to the future opportunities working closely with the Niagara-on-the-Lake Chamber.
Thank you, Matt. Mark, did you want to add a few words there?
No, I think Matt and yourself said it all, and it's just a big thank you to everybody for attending, and I think we're all looking forward to more conversations. And again, as part of the agreement that we have with the Chamber, you can reach out anytime whenever you have any questions or difficult situations. We'll be happy to help you, even if you are not clients of HR Covered. We'll at least be able to guide you in the right direction for whatever you might be facing. So remember that you're not alone. There's always someone in your corner there to help you and support you and guide you with those very gray and sometimes complicated to understand legislations.
And I want to thank you, Mark and Matt, for facilitating and helping with this. And thank you to the audience and Ryan. I've had a blast. It's been a while since I've done one of these, and Absolutely loved it. So thank you for listening to me.
Thank you, everyone.
Okay.
Take care, guys.
Bye-bye. Take care.